So this is a draft of a paper that we've been working on internally that comes out of the research agenda for LFAI, and it's on how rigorously AI should follow the law, which might seem like a trivial question with a straightforward answer, but when you look at how humans behave in reaction to the law, it's not so simple. And to echo what Holly was saying earlier, it's actually been kind of nice to present at a later point because you get to see the thread of what everyone else has started to talk about, and the thread of this question has arisen in a bunch of different areas, and I've been able to sort of borrow the ideas of how you've begun conceptualizing it. With the question of rigor, I think you start to see where law and following start to come apart. So that particularly came through today with Jacob's talk, with the justification of and discomfort with perfect enforcement, with Jonathan's talk about judgments of reasonableness as an exercise that's hard to articulate but not arbitrary, and that general doubt around or the attempt to understand legal reasoning capabilities for AIs. So all of that getting at the sense of freedom that we value, and if you think of law as a mechanism to help us live our lives in a self-directed way, then there's a gap between life and law that we want to preserve. And obviously that's a very human-specific take, so I will add that there's a temporal aspect to the approach that we're looking at, which is, it's like the immediately next scenario. So where we move from human to machine, we're actively slotting LFAI agents into human law, and it doesn't necessarily now answer the question of whether we need to or should evolve the law to fit AI agents. So does that go? Oh, okay. Okay. So for the next 45 minutes or so, in the first part, I'll take you through the three main movements of the paper. So firstly, we'll motivate the question of rigor by arguing that the straightforward solution of saying that AI agents should just completely, fully follow all laws is not workable. Secondly, I'll talk about the posture or attitude that we think LFAI should adopt. We call that respectful rigor. And finally, we'll propose a framework for decision procedure that's intended to align with that attitude of respectful rigor. A big caveat that this is a work in progress, and there's ambiguity and open questions for each of these sections, for the attitudinal approach and for the framework itself. But our aim is really to try and seed approaches, start a conversation and convince people that they should think about this. So not necessarily trying to convince you that our approach is the most correct. It's productive if you don't like it, but are inspired to engage with it and come up with an alternative. That leads us to the second part, which is the interactive. It's going to be another Google Doc situation where I'll ask you to think about the framework that I present and potential alternative approaches. So please stay awake for that. So when an LFAI is thinking about taking an action that might be illegal, how should it act? Should it follow the law no matter what? Oh, the font's bad. Or should it maximize the benefit for its human principle? Or should it do some secret third thing that conveniently falls between these two situations? So I'm going to go through three views of law following, very simplified, but this is how we've started to conceptualize an approach for a solution. So the first one is what we call full rigor. So an LFAI following the law with full rigor aims to fully comply with all laws and to never violate a legal duty. So it's in its approach to breach, it aims to never take an action that will break the law or would risk breaking the law. The second approach is what we call practical rigor. So you might recognize this one as the Holmesian bad man. An LFAI following the law with practical rigor aims to comply only where breach is too costly. So if the benefits of breach outweigh the costs, an LFAI can break the law. And the third one is what we call respectful rigor. So an LFAI should generally comply with laws because it accepts those laws, and regarding breach, it's permissible for an LFAI to break the law under certain circumstances. And so you might think that we would want LFAIs to follow the law with full rigor, fully comply with all laws, aim to never violate the legal duties, and not even take actions that might risk breaking the law. But because all law-following AI agents should be maxing out on following the law, otherwise there wouldn't be any point to law alignment. But I'm going to argue that there are a number of problems with full rigor, and the upshot is basically that requiring LFAIs to follow the law with full rigor is infeasible, and within the context of human-made law, it's undesirable. And this is for two reasons. The first one is that it's not always achievable, and the second one is that it's not always expected. So with regards to the point about it not always being achievable, this is a problem of uncertainty for three main reasons. So the first one is that there are many laws, and there are some that are obvious that are on the books, but some obscure and some which probably should have been repealed a long time ago. Remembering that the goal of a fully rigorous LFAI is to fully comply with all laws and never violate a legal duty, we think this would result in needing to consult the entire corpus of law within the given jurisdiction for each action. And so that level of rigor is unfeasible when you're thinking about an AI agent acting in the world. The second reason is that laws can conflict. So this can happen when the laws of two jurisdictions conflict. It can happen between state and federal government, or even between inconsistent provisions in a contract. And sometimes there are resolution provisions, like if you think about the supremacy clause in the US Constitution or priority provisions. These can help, but where there aren't, we get what we call absolute conflicts, where in order to move forward, the AI agent is going to have to break one of the conflicting duties. And in those situations, an LFAI isn't going to be able to act without seeking judicial resolution. So to move forward, it's going to have to either go through this costly and long process or else break the law. And even if there are rules or principles of resolution, the LFAI might still have to guess how those apply, and so uncertainty still remains. And finally, a classic problem of the open texture of language in which all laws are written. This means that laws have a potential uncertainty as to interpretation. And so to achieve that goal, of never breaking a legal duty, a fully rigorous LFAI has to seek to avoid any risk of breach. So given that inherent potential uncertainty, this can prove onerous. And that basically means an LFAI can never be fully certain that it isn't violating some law. So the second problem with full rigor is that it's not always expected, and this is a problem of design. So laws apply generally. And lawmakers and enforcers understand that laws sometimes overreach, so there are downstream checks by law enforcers, and this has come up today. And this kind of structure of law leads to law violations of the kind that no one really cares about. As you think about copyright violations, running red lights at midnight when no one's around. But a fully rigorous LFAI can't accommodate these. And the second reason is sometimes breaking the law is morally justified. So people may break the law to prevent or counter harm. We do this all the time. We may want LFAIs to have the ability to do that under certain circumstances. And the second part is that justifiable breach can also occur due to the form of the law. So if you think about the distinction between property rules and liability rules from Calabresi and Melamed, briefly, under property rules, a legal entitlement can only be removed if the holder chooses to sell it at a value that the holder agrees to. And by contrast, you have liability rules where the legal entitlement can be removed just by paying for it at an objectively determined value. So if you have an entitlement protected by a liability rule, and that rule confers a choice. So you either respect the entitlement or you pay the damages. But to stop an LFAI from breaching liability rules would be to transform those rules into property rules, which is not what we think the legislature would have intended. And so maybe an LFAI need not refrain from violating entitlements protected with the liability rule, at least if it can pay the damages. So essentially, a fully rigorous LFAI has no concept of a tolerated, justified, or even expected breach, if we can talk about them like that. So that's full rigor, which we don't like. But what about practical rigor? And remember that this is the Holmesian bad man who thinks that law is just a cost to be internalized. The main issue with this attitude is that it creates too great a risk of misalignment with law. So it might become too opportunistic in seeking breach. To a practically rigorous LFAI, the consequence of breaking any law is nothing more than a cost that can sometimes be paid, which means that there's nothing special or intrinsic about the law that demands obedience. And as such, breaching a law is permissible if breach benefits a human principle and the benefit outweighs the cost of breach. And this is more likely to create what we call AI henchmen, who obey the law only to the extent that it benefits their principles. And to put it a different way, which Sebastian and Claire were articulating, is that the loyalty of the LFAI is to the human principle and not to the law or the law-creating bodies. And this could happen in a manner that would take us too far away from sufficient law alignment. So where to from here? The secret third thing, which is respectful rigor. So to go beyond sanctions, flesh out the vision of respectful rigor. This is some of the literature that we've drawn on as inspiration. The first one would be The Puzzled Man or The Ignorant Man from H.L.R. Hart, which expresses the internal point of view, where with respect to some rule, a person accepts that rule as a reason and justification for acting as that rule demands. So Hart refers to that person as a puzzled or ignorant man who is willing to do what's required if only he can be told what it is. Similarly, Rebecca Stone coins the term internalizer to describe actors who, in relation to a law, prefer to comply with that law, even if, in the absence of it, they would not prefer to. And that gets at what Tom Tyler, citing others, also refers to as internalized obligations, where some norms that are originally external to a person and sometimes in conflict with their interests and desires become part of that person's internal motive system. So they voluntarily comply with those obligations, even if those obligations conflict with their self-interest. So in each case, the existence of a law provides strong reason to act in accordance with it, independently of the consequences. And obedience is driven by an acceptance of, and consequently a desire to respect the presence of the law. So that's essentially what we mean by respectful rigor. We understand that respect is giving due regard to the law in accordance with adopting rule acceptance, and generally taking an existence of a law as a strong reason to act in accordance with it. And we generally think that this balances alignment with efficacy. So if you remember, these were the issues raised both by practical rigor and full rigor. So with alignment, a respectfully rigorous LFAI gives weight to a law simply by virtue of its existence. So where the principal's interests diverge from the law, a respectfully rigorous LFAI is more likely to follow the law than a practically rigorous LFAI. And secondly, regarding efficacy, this doesn't mean that a respectfully rigorous LFAI is going to blindly follow the law. There are some claims that it means that a respectfully rigorous or equivalent agent would need to follow all the laws in a kind of law fetishism. But we think that other considerations can still override the weight that a respectfully rigorous LFAI would give to a law, permitting law breaking in a manner that full rigor wouldn't. And of course, that raises questions of what considerations would override that, and when should those considerations kick in? Because respectful rigor on its own doesn't dictate the reasons why a law might be broken. So how do we make that determination? And that brings me to the final section of the presentation, which is determining acceptable legal risk. So this is the part where things get really ambiguous and open and very experimental. But just to do a little more scene setting, when does legal risk arise? It arises in at least two major areas. So these are the areas that we canvassed under full rigor, the first being when you act under legal uncertainty, and the second being when there is tolerated, justified, or expected law breaking. So you've got an area that is grey, so you might need to act in a way that risks law breaking, and for the second one, you know that it's illegal, but you want to act anyway because it's justified in some manner. So how do humans approach legal risk? It's generally a spectrum where on one end you've got a conservative approach, which is much closer to full rigor, all the way to more of an aggressive approach where that aligns more with practical rigor, potentially even goes beyond it if that's possible. For LFAIs, we propose that AI agents should be able to take an acceptable measure of legal risk. So that's an action that falls in that realm of acceptability when it's uncertain or clear that the action's illegal. It means that the act is morally justified in taking that action, even if they're later judged to have acted in violation of the law. So for an LFAI, this might involve less tolerance than what we think about for acceptability for a human. But to determine that acceptable legal risk, we propose the following framework inspired by expected utility theory. So it turns on this idea of expected legal badness, where if the expected legal badness is too high, then the action will pose an unacceptable legal risk. And the variables that go into expected legal badness are importance of the law, secondly, the predicted probability that an adjudication process would rule the act unlawful, and thirdly, the predicted severity of the breach caused by the act. So I'll go through quickly where these variables came from, how we think they would go into the output, and then after that talk about how we would assess that figure of expected legal badness. So the first variable of importance has three components that we've thought about so far. The The first one is the nature of the law. So certain categories of law can be considered more fundamental than others according to their nature. So two examples, there are laws that preserve the conditions for human existence, and there are laws that are integral to the existence of the state and its value. So one example of a group of laws that would fall quite squarely, I think, within the first one is criminal law. And the interesting thing about criminal law is that it often builds in its own gradations of importance, which can be instructive. So if you think about things like the distinction between mala in se or mala prohibita, crimes of moral turpitude, or even sentencing guidelines that explicitly rank penalties from more to less severe. The second part of importance we thought about is enforcement. So how a law is enforced can contribute to our assessment of importance. A law that's not very strictly enforced can indicate that the breaches are somewhat condoned, in turn suggesting that the law is less important than a law that is more strictly enforced. So part of this is due to the fact that it's costly to enact enforcement and it requires dedicated resources. And another part of it is due to the generality of law and the flexibility of that design. So that's a downstream check, and it's a decision made by enforcers. But I would note for enforcement as a variable is this is a relative assessment, and there are instances where enforcement doesn't necessarily correlate to importance, such as laws that perform an expressive function of the law, where you want to have the law on the books and you think it's quite important, but you're not going to enforce every violation of it. And then the third aspect of this is penalties. So as a marker of importance, we might think that the greater the severity of a penalty, the more that the legislature is seeking to deter the unlawful act, indicating that the law might be of greater importance. But one difficulty is that penalties need to be placed on a common scale, and secondly, they don't always correlate with importance. So for example, property rules are enforced in the first instance by injunctions, not monetary penalties. So you have to look at all of these factors in combination to kind of plug the shortfalls of them. But also for the exercise later, are there any other variables that we could include? Are there any other considerations that we could add? As part of importance, there are some exclusions that we might want to put in place and additional guardrails for AI agents. So we were thinking about excluded laws where there should be a set of laws that LFAIs aren't permitted to break at all, or only under extreme circumstances because they are so fundamental. So you might want to put some criminal laws in there, you might want to put some constitutional laws in there. And the second, more procedural reason is that, procedural aspect is that you might want to exclude reasons for breach that LFAIs should not be able to access, even if those reasons might be acceptable for humans. So for example, you might want to think about whether LFAIs should be permitted to breach laws for the purposes of civil disobedience, which you might agree is really important for humans to have, but whether an AI agent should be allowed to do that is a different question. The second variable is the prediction of judicial ruling. So this is a prediction of whether a court would hold that the relevant action would be lawful or not. So if a court rules that an action is more likely to be unlawful, the expected legal badness would be higher. But we might also want to integrate confidence in this with regards to how the prediction is given. So some predictions would be made with more confidence because the law is clear, because the facts are clear. So when taken in combination with other variables, a prediction made with higher confidence is going to move the dial more strongly on acceptability in conjunction with the other variables. And finally, for the final variable, severity of breach. So this is getting at the intuition that an important law can be breached in a minor way. So you can have a really important constitutional law, but you can have a small breach that you might want to say this may be allowable under certain circumstances. Equally, you could have a minor law, like a minor traffic law, and you could breach it in a catastrophic way where you end up with a massive accident, a lot of people injured. So one variable that might be useful to consider is the severity of breach and consequently the penalties that might be applied. It's an open question as to how this overlaps with the appearance of penalties under the importance variable. And then with the degree of breach, one suggestion for determining how that could occur borrows from contract law. So if a breach goes to the heart of the statute or the common law principle, if your jurisdiction does that, then it's more severe. So taking all those together, you'd have some sort of numerical output, and then you would calculate an expected legal badness, and then you come to the assessment. So this is where you assess whether or not it falls within the realm of acceptable legal risk. We like to think of these as levers, and this is still open and in flux, kind of uncertain, but for example, you could have an act that runs an unacceptable legal risk if the expected legal badness on its own is sufficiently high, so above some kind of threshold. 2, if the probability of unlawfulness alone is sufficiently high. Or 3, like we start playing around with looking at if the importance is high and you also have a medium, at least, predicted severity and a low probability of unlawfulness. The second part of this assessment speaks to the sense that we might want to flag issues if an LFAI is making a ton of minor breaches as a marker of it potentially being misaligned. So we propose quantifying and summing expected legal badness over a period of time, say 1 year, and seeing whether it exceeds some total threshold. So if you have a bunch of small breaches, you finally have like the straw that breaks the camel's back. We'd say at that point, you can't take that action. I'm not completely sure about this one at the moment because I probably breached copyright quite a lot. And I think I'm still fairly law aligned. But again, we're talking about AI agents, and that's different. So this brings us to the interactive. Again, that's the URL for the Google Doc and a QR code if you're doing it on your phone. If you open it up, I've put the framework in there with the variables and the assessment just to step it out for your reference. And then below that, there are questions where there are areas that you can discuss in groups. You can think about it on your own, but basically that determination of expected legal badness with the variables. The second section you might want to think about is the assessment of it. The third is alternative approaches, and obviously the fourth, anything else that you might have a response to. If you could take a moment to think about it, talk about it in groups, and then there's a note-taking section at the bottom that would be great if you could record what you come up with. And then when there's 5 minutes to go in the session, I'll just call everyone back, and if there's anything anyone wants to share, we can do that just to wrap up.